Good to go?
Hello, everyone. Thanks for joining us. We are going to just wait a couple of minutes to make sure everyone gets a chance to log on. Just wait about one more minute. Just want to make sure everyone who wants to be here right at the beginning has a chance to be here. All right. Well, welcome everyone. A formal welcome to our quarterly sample policy update series. And today we will be talking about our December 2024 update packet. We typically have them in the same month that we release the packet, but with the holidays and AEC, we usually do our December update packet in January. Next slide, please. All right, so we will just briefly go over the webinar agenda for today. First, we'll do some housekeeping and presenter introductions. We're going to have a few polls. We're going to do poll number 1, which is going to be about composition of attendees. But prior to that, we're going to do a fun poll, kind of get used to the polls. Then Gamut overview, a little brief explanation of Gamut. Then we're going to go into the heart of our discussion about our policy updates, as well as some questions and answers. And then we will have our poll number 2, which is an evaluation of the webinar and how good we're doing or not doing. And then at the very end, time for additional questions. Next slide, please. All right, so for the housekeeping, questions and answers and a link to the presentations. So please use the Q&A feature to submit your questions. And as you can see from the visual where that is located, a little bit below the speaker, and the chat feature has been turned off. So please don't use the chat feature for a question. And then your questions, so we will answer them either in writing through the Q&A, or we will do it live by our presenters, either at the end of each section or at the very end of the presentation itself. And please know, I know this tends to be a big question, but everyone will receive a link to the video of this webinar as well as the slide deck. Okay, next slide, please. So we'll just go over briefly who is going to be presenting today. So I'm Barbara Leifman. I am the Director of Policy Manual Development. And then we also have Dustin Bindriff, who's a Senior Policy Manual Writer, Mariela Martinez, who's our Senior Legal Services Attorney, Megan Russell, who is another Senior Policy Manual Writer, and Josh Daniels, who's the Chief of Policy and Governance Technology Services. Next slide, please. Okay, so here's our fun poll. This is the practice one. We thought it would be fun with the Super Bowl coming up to have a poll about the Super Bowl. So the question is specifically who's going to win the Super Bowl. Will it be A, Kansas City, B, Philadelphia, or the last one is Kendrick Lamar. So let's take a few seconds to submit your choice, and then we'll look at the results. Okay. Hope everyone had a chance. Okay, So it looks like Kansas City is the favorite, and then Philadelphia, and then Kendrick Lamar is third. That was just kind of a funny one. Okay, so next slide, please. And hope everyone's got the hang of it now. So here's our first formal poll, which is the composition of our attendees. And this really helps us in order to present the material appropriately for who's attending. So your participation in the poll really helps us. So the first question is, have you previously attended one or more update webinars? You can choose no, this is my first one. Yes, I have previously attended one or two, or yes, I have previously attended three or more. Have a second question. What is your role in your district or county office of education? Is it board member, superintendent or administrator, executive assistant, or other? So let's take a few seconds again. Okay, hopefully everyone's kind of wrapping up, and now we will look at our results. All right, so for the first question, have you previously attended one or more update webinars? The majority by a little bit is it's the first one. Then second is those who attended one or two, and third is attending three or more. And in terms of the role, it looks like heavily weighted for executive assistants, and then a little bit smaller superintendent or administrators, and then board members. All right, thank you so much for participating. Like I said, it really helps us. All right, next slide, please. Okay, so we're going to talk just very, very briefly about using Gamut to access the update packets. Next slide, please. So we're going to go over a few visuals. There we see it. So just to show you really to really pinpoint like what you would need to click on. So via the Gamut policy site, if your district subscribes to Gamut policy, but does not have your own Policy Plus site, you'll find the update packets on the Gamut policy site in the policy update section. And if you look at the little yellow arrow, you can see exactly what you would need to click on once you are onto the Gamut policy site. All right, next slide, please. And here's a visual to say that it's basically the same thing for county offices of education. And you can see where you need to click, and then the update packet will show appropriately under title. And again, this is for county offices that subscribe to Gamut but do not have your own Policy Plus site. Okay, next slide, please. Now we're going to get into districts and counties that do have their own sites. And the packet, you'll find it a little bit different. So it's under policies, and you'll click on CSBA communications. Next slide, please. And then very similarly for the county offices of education that have their own site. Okay, next slide, please. So Gamut, we do offer virtual support, webinars and webcasts, excuse me. And the Gamut team hosts weekly drop-in sessions every Wednesday at 2 in the afternoon. And this is a link that you can use to register for those very helpful sessions. All right, next slide, please. So we know that sometimes districts and county offices aren't able to always get to the packet. So if you have missed several update packets, we have a few different services that you might find helpful. One is a policy manual review, and the other is a policy development workshop. The review is an audit that lets you know which policies you may need to update. And a team from CSBA will compare the last revised date of your district's policies with those of its manual and issue you a report, and then your district or county office of education can use that report to be helpful to keeping your packets and your manual updated. Or we offer a policy development workshop, which CSBA consultants will work with you side by side to really update and tailor your entire policy manual. Next slide, please. Okay, so we also offer a service where Gamut Policy Plus and meetings can be combined. And there's a lot of advantages from this, which are listed on the slide. I'm not going to go into each one in detail, but if you want more information on this, again, you can contact our policy link that I gave previously. And there are some very helpful and good reasons for having both the meetings and the Policy Plus combined. All right, next slide, please. And now I'm going to introduce Mariella, who's going to briefly discuss the services offered by CSBA's legal services.
Thank you, Barbara, and hello, everybody. Thank you for joining us this morning. As was mentioned at the outset, my name is Mariella Martinez, and I'm a senior legal services attorney with CSBA's Legal Services Department. I'd like to tell you a little bit about what it is that we do. And basically, in a nutshell, Legal Services is a subscription-based program that's designed to provide CSBA members with cost-effective legal advice and resources. More specifically, though, what is it that you get as a legal service subscriber? Well, you, as a subscriber, a district or county office has access to CSBA attorneys, and we can assist with just about every education law related topic you can think of. Some of these are on the slide here, to include independent investigations, special education, Brown Act compliance, et cetera, et cetera. It really runs the gamut. In addition to access to CSBA attorneys, as legal services subscribers, your district or county office would also have unlimited access to our resource library. And that is a repository of CBAs, MOUs, salary schedules, as well as legal resources that are specific to education law. So our library is really a great tool. It's a great tool for labor negotiations, general education law information, and research. We could move on to the next slide, please. Okay. So as I mentioned, our services are very affordable. The subscription fee is only 10% of a district's or county office's annual CSBA membership dues for any given fiscal year. And because we are in the middle of this fiscal year, we're prorating our subscription fees. In addition, all new legal services subscribers receive the first 3 hours of attorney time free of charge, and districts and county offices that are Gamut Policy Plus subscribers also receive 2 free hours of policy-related legal work when they sign up for legal services. So that's potentially $1,000 of legal work free of charge, as our attorney time is billed at just $200 an hour. There are other perks, of course, that our subscribers receive. I'm not going to get into them in the interest of time, but please do reach out if you have any questions or if you would like any additional information about our services. That's it for me now.
Okay, so we are going to talk, before getting into the content of the packet itself, just a little bit about the basics of sample policies. Next slide, please. So just a few things to know. So board policies, that's the way that the governing board legislates, and they really articulate the policy direction of the district or county office of education. Then we have our administrative regulations, which provide necessary details while staying within the confines of the applicable policies. And it's really the way that the superintendent can use these regulations to implement the board policies. So it also shows how the board and the superintendent are working as a team, with the board clearly within its purview by laying out the direction, and the superintendent then using the administrative regulation to implement that. Please know that the structure may not apply to county superintendents just because of the different dynamics between the county superintendent and the county board of education. We also have exhibits, which provide forms, notices, and other implementation tools that are consistent with the board policy or regulation to which it relates. And these can be very important notices, forms, and just easy access to help you with implementation of the policy and regulation. And then there's board bylaws, which are specific policies that provide the rules and procedures that the governing board itself must follow, and also are adopted by the board. Please keep in mind that policies, we use this term kind of interchangeably for the board policies, the regulations, the exhibits, and the board bylaws. So when we use it kind of generically, whether in the webinar or when you're interacting with CSBA staff, or maybe even within your own districts and county offices, just remember that we might be also really meaning a specific document and a specific type of policy or document rather than the generic term. All right, next slide, please. So you're probably aware, but our manual has a numbering system. It ranges from the zeros to the 9,000s. We specifically kept the 8,000s blank just as a placeholder. A couple of things to point out. The 2000s, which deal with administration, are applicable only to districts, again, because of the different dynamics that are in county offices of education. For the 4000s personnel, it gets a little tricky sometimes because the ones that say 40 and then two other numbers apply to all types of staff. The ones that are the 4100s apply to certificated staff. 4200s is classified staff, and 4300s are supervisorial or managerial staff. Sometimes, to make things a little more complicated, two of the policies, or three of them, will apply to all or a couple. And in those cases, if it applies to two, so say it applies to certificated and classified staff, and the language within those is identical, we call that double coded. If it applies to all three, it would apply then to, it would be called triple coded, and the language amongst all those three would be identical, even though there's different staff. We also do have, just so you know, what I call singletons, and that means that for certificated, classified, and or managerial staff, they are all unique. So they wouldn't, you wouldn't want to use one for the other. So in total, there are over 800 sample policy documents. And remember that we sometimes call regulations, board policies, exhibits, and board bylaws policy. So in terms of documents, which encompass all of those, we have over 800. And if we're looking at the code numbers, we have about 550, a little over. Most have a board policy. Some unusual circumstances just have an AR when it's very procedural. Next slide, please. Okay, a few more things to know. We talked about that we're using a collective word. Please keep in mind, though, that these are samples and they are a starting point for your district or county office of education to refine and to create it and make it unique for your district or county office. And it's really, I don't know, when I was a board member, part of why I really liked policies, because it was definitely an area within our purview. Not only do we have control, but more interestingly, how we could create and develop policy that really reflected the priorities of our district. So I actually really enjoyed that part of it, and hope you do too. Please know that our policies do go through extensive legal review, but they are not meant to constitute legal advice. And as hard as we try to keep up with the legislation, they do become quickly out of date. So it's always something to keep in mind about the currency. We do have notes. I don't know how many of you have seen the notes that are embedded to provide context and additional guidance. I hope you do have access to the notes because they really provide a lot of explanatory information, but they should not be included in the adopted version of the policy, which just contains the body language itself. Next slide, please. All right, so now we are going to get into the content of our policy updates for December. And I'm going to start by introducing Megan and Mariella. Mariella is going to speak specifically to independent study. Whoops, I was one slide ahead of myself. First, let's look at all the policies updated in the packet. And now we will move on to student opportunities. Okay, let's slow down for one sec. Okay, so here's our slide about the December packet. This is where we list all of the policies that we updated. We have them divided according to how we will speak about them and present about them into 4 different sections. We're going to highlight just a couple within each section. And we will have questions, like I said, at the end of each section as well as at the end of the webinar. So if you have questions either related to one we have highlighted or one we have not highlighted, please feel free to ask your questions. All right, now we will go on to our first section, which is going to be student opportunities, achievement, and instruction. And I'm going to introduce Megan and Mariella. And as I said, Megan's going to head off and Mariella is going to join about independent study.
Thanks, Barbara. So I'll be highlighting 2 policies, chronic absence and truancy, and then Mariella will be discussing independent study, and we'll also briefly touch on all the other policies that we have listed in this section. So we updated Board Policy and Administrative Regulation 5113.1, chronic absence and truancy. We updated that to move language from elsewhere in the policy to the first paragraph in order to emphasize the importance that students who are identified as chronically absent or truant should receive appropriate support, services, and intervention as early as possible. We also updated strategies for encouraging student attendance, and those were identified in a CDE webpage called School Attendance Improvement Strategies. And we also updated the board policy to reflect Senate Bill 153, and that authorized districts and COEs to implement attendance recovery programs beginning July 1st, 2025. And I'll talk a little bit more in detail about these attendance recovery programs in the next slide. But right now, I'm going to also mention that we updated the administrative regulation to reflect Senate Bill 691, which makes changes to the truancy notifications provided to parent guardians, and also deleted language from the administrative regulation related to the delay of driving privileges. Next slide, please. So the administrative regulation is where most of the information about these new attendance recovery programs are located. And so these are authorized under Senate Bill 153, and districts can begin offering those to students July 1st, 2025. And those are for students in grades TK through 12, so all students, to make up lost instructional time and offset absences. And on this slide, we list the requirements of those attendance recovery programs. And that's limited to 10 days of attendance or lost instructional time to offset absences incurred during that school year. And students cannot be credited with more than 5 days of attendance per school week or more than 1 day of attendance for any calendar day of participation. So kind of a one-to-one. If you missed 1 day, then you could make up 1 day under an attendance recovery program. There's some flexibility that these programs can be operated before or after school, on weekends, during intersessional programs. And districts who are offering these attendance recovery programs have to offer them throughout the school year, including one during each term, so each semester or trimester. And these are intended to be limited term options for classroom-based regular educational programs. And students cannot be required to participate in these programs. And students who are participating in an ELO program must retain the ability to participate in those expanded learning opportunity programs. Next slide, please. We also updated the administrative regulation to note that students who are in these attendance recovery programs must be engaged in educational activities and content aligned to the grade level standards, and that they have to be under the immediate supervision and control of a certificated teacher. There's also student to teacher ratios, and the districts who offer these attendance recovery programs are required to maintain certain documentation about how they have complied with these ratios. So next slide is going to be independent study, and Mariella is going to speak mostly to independent study here.
Thank you, Megan. We are going to start with BP 6158. Independent study, as Megan mentioned. Most of the independent study revisions are driven by new legislation this time around. So it makes sense to take a look at them from a legal perspective. So I'll be covering this topic. So there are two main pieces of legislation here, and they are SB 153 and AB 176. Both of them became law this past year. So BP 6158 now reflects the following requirements for both SB 153 and AB 176 for districts that submit affidavits for school closures necessitated by emergency conditions. So what I'm going to speak about next come from both of the pieces of legislation that I mentioned. So I do want to stop and make a little comment here that Education Code 46392 specifies what these emergency conditions are, and they include what you would imagine: earthquake, epidemic, flood, fire, which is very relevant right now, among others. Okay. So first, for an emergency event that occurs after September 1st, 2021, but before July 1st, 2026, the district must certify that it has a plan for offering independent study to affected students within 10 instructional days. Second, for events occurring on or after July 1st, 2026, the district has to certify that an instructional continuity plan is included in the comprehensive safety plan, that student engagement and instruction was offered consistent with the instructional continuity plan, or certify that instruction was not offered consistent with it due to extenuating circumstances. We could move on to the next slide, please. Okay. So there are also some updates to the board policy that are based on SB 153 alone, and I will discuss those now. First, when you're computing ADA, students participating in independent study may only be credited with 1 day of attendance for each calendar day. Second, specified independent study requirements are applicable only when students are participating in an independent study program for more than 15 school days in a school year. Third, evidence of student participation may include documentation that student participated in instructional period, either that the student participated in an instructional period, either visually or verbally. Fourth, a written agreement is required for independent study of any length of duration, and that is because districts may now claim independent study ADA for any length of duration as well. The previous 3-day minimum duration to claim independent study ADA has been repealed, so that is no longer at issue. Okay, let's keep going with our list. And fifth, SB 153 requires districts to obtain a signed agreement at specified times. And this gets a little bit complicated, and it does have some legal wrinkles. So I'll go through those and hope that you're able to get a sense of what's going on and when you need to reach out to legal counsel, whether that's CSBA's legal services or other legal counsel that you work with. All right, so I mentioned that SB 153 requires districts to obtain a signed written agreement at specified times, right? So that's before the beginning of independent study, for independent study of more than 15 school days. However, for shorter periods of independent study, shorter than 15 school days, during the year in which the student participates in independent study, that's when the agreement has to be obtained. So I mentioned a wrinkle, and here it is. Education Code 51747, which was amended by SB 153, clarifies that for independent study programs of 15 school days or fewer, the agreement may be signed at any time during the school year, right? As I just mentioned. But it also includes legislative intent that parents and guardians be provided the written agreement at or before the beginning of the school year. So there seems to be a contradiction between the language of the legislation and its legislative history. In addition, Education Code Section 46300.7 states that apportionments shall be received for a student in independent study only if the district receives written permission from the parent guardian before the independent study begins. specifying the actual dates of participation. It also has to identify the methods of study and evaluation and the resources to be made available for the student's independent study. So Education Code 46300.7 and Education Code 51747 are inconsistent, right? Regarding when written agreements need to be signed for programs of 15 school days or less. Here's where we encourage you to consult us at CSBA Legal Services or consult your other counsel. Just a warning here, and that is that in order to avoid findings and associated penalties in the annual audit, statutory compliance must be in place before claiming independent study ADA. And yet another reason why you should, when you're dealing with this, reach out to legal counsel. As a final note regarding SB 153, it does make similar changes to course-based independent study as well. So just keep that in mind. If we can move on to the next slide, please. Okay. So we have a few other changes to mention with respect to Board Policy 6158. And first, there's SB 348. Which became law in 2023. I haven't mentioned it before, but SB 348 requires districts to make available at no cost nutritionally adequate breakfast and lunch to any student upon request, including independent study students scheduled for educational activities that last for more than 2 hours at a school, resource center, meeting space, or other satellite facility. And this is regardless of the student's eligibility for a free or reduced price meal. And second, there is a clarification regarding the meaning of caregiver. That's in the context of general independent study agreement requirements. And this clarification makes it consistent with similar material related to course-based independent study agreement requirements, so that a person essentially who is 18 years of age or older, who completes and signs a caregiver's authorization affidavit declaring the minor lives in that person's home, is authorized as a caregiver. And that allows that caregiver to enroll the minor child in school and consent to school-related medical care on behalf of the minor. Okay. Finally, the administrative regulation, the corresponding administrative regulation was updated for two purposes. And first, to reflect AB 176, clarifying the traditional independent study requirements to maintain documentation of hours or fractions of an hour for both student work product and time that was engaged in asynchronous instruction. So as a result, districts are going to have to document hours or fractions of an hour before converting to days of attendance. Finally, the update deletes material that is related to students with disabilities who receive services from non-public, non-sectarian schools through virtual programs. This law is no longer operative as of July 1st, 2024. Just in case you were wondering what that language was that was deleted, it provided that any student with disabilities who receives service from a non-public, non-sectarian school through a virtual program could be permitted to participate in independent study if the student's IEP team determined that FAPE could be provided to the student by means of the virtual program and other conditions of law are satisfied. So that is no longer operative as of July 1st, 2024. I think that is it for me. I think we'll be turning now to a discussion of BPAR 0460 on local control and accountability plans, unless there are questions.
Thanks, Mariella. I think we can run through these last couple of slides in this section, and then we'll turn to questions. So as part of these student opportunities and achievements, section that we're talking about today, we also updated BP and AR 0460 Local Control and Accountability Plan. And that was updated to reflect SB 153, which requires learning recovery emergency funds to be included in the July 1st, 2025 through June 30th, 2028 LCAP or annual update. And SB 153 also extends to July 1st, 2027, when the IDEA addendum is required to be completed. SB 153 also says that if a board is unable to review local indicator data due to an emergency, the board is required to review that data at its next meeting and adopt a resolution describing the emergency and the date on which the local indicator data was reviewed. SB 153 also requires the superintendent to present an annual update and budget overview for parents and guardians as a non-consent item at a regularly scheduled board meeting. We also updated 0460 to reflect SB 114, which requires districts that receive LCFF equity multiplier funding to include specific goals in their LCAP for each school generating such funding. And then there's a distinct COE version of 0460, and for that, the BP was updated to reflect SB 153, which adds charter schools to the required summary of how districts and schools will be supported. Next slide, please. And part of the December packet, we also updated 5148, childcare and development. We updated that to reflect SB 722, and that requires submittal of completed incidental medical services plan to the California Department of Social Services, but authorizes the district to enroll a child prior to the CDSS approval of the plan. And then for students with disabilities, a student can be authorized to attend the program prior to approval of the incidental medical services plan, as long as those forms have been submitted by the district to CDSS. And then we also deleted from the board policy the requirement to provide distance learning when a child care program is physically closed by a public health order because that the provision is no longer required. Next slide, please. The AR was also updated to reflect AB 393 that requires a teacher or other designated staff member to conduct a family language and interest interview for student identified as a dual language learner, but prohibits the family from being compelled to complete that survey. And AB 1808, which provides the family who receives CalWORKs is considered to meet eligibility for not less than 24 months. Next slide. We also updated 5148.2 before and after school programs, and again, SB 153, and that requires beginning in 25-26, the board to declare its operational intent to run an expanded learning opportunities program to CDE, and also authorizes districts and COEs to use ELO funds to support attendance recovery programs. And then the AR was updated to reflect a number of bills also, which require districts that operate intercession programs to grant priority access to foster youth and students experiencing homelessness, and for the educational rights holder to make a determination of which program they're going to be attending. And then also requires a district that receiving ELO apportionment to provide transportation to students who attend a school that is not operating an ELO so that they can attend the ELO program and then return to the original location or another location. Next slide, please. And then we also updated preschool and early education. And so we reflected SB 163, and that made a change that CSPP programs are able to enroll 2-year-old children And that's a new requirement. And then we updated the eligibility in order to reflect those requirements as well. Next slide, please. And then we also updated transitional kindergarten 6170.1. And that was some of the things that we talked about earlier about the English language assessment. And then also to reflect SB 153, which requires a new classroom observation tool. And then it's just something to note for this policy, there is no accompanying AR. Next slide. English language learners was also updated, and that is updated to require CDE to develop statewide implementation plan for their EL roadmap policy. The term newcomer student was clarified, and it has the same meaning as immigrant children and youth. And also language, long-term English language learners are numerically significant subgroup who have not attained English language proficiency within 7 years of initial classification. And again, TK students are exempt from the initial identification as English learner assessment. So there was a lot of information in that section.
Okay, thank you, Megan. So we will now go to questions for this section. So we'll try to handle some questions about the policies Megan and Mariella just discussed. So the first question is about chronic absence and truancy. So that would be 5133.1. And the question is, can a district require a student on an inter-district transfer to attend attendance recovery programs? So I'm not sure if somebody else wants to take the question. My general impression would be no. I don't know that this is specifically stated in law, but I do know the general law that you are not supposed to treat inter-district transfer students differently than your regular resident students. But I would look to my peers if they have anything to add to that.
I'll just add that the Education Code 46211 specifically says that participation in an attendance recovery program shall not be compulsory or punitive for students.
Correct. Thanks, Megan. I think when you put those two together, our combined answer would definitely be to not require something of an inter-district transfer student that you don't require of your own resident students. Okay, next question, also about chronic absence and truancy. For attendance recovery programs, can a district implement an attendance recovery program without the board updating its policy? So again, I'll take a stab at this. Yes, I think so. It's not a mandated policy requirement. And it's also authorization to do it. Districts do not have to offer an attendance recovery program. So my answer would be you don't have to update your policy. We would always recommend updating the policy. It's very good to have policy which reflects your practices in your district or county office. But yeah, so I don't know if my peers want to add to that one before we go on to our next question. Okay, the next one is about independent studies. So remember, this is 6158 is the number for the policy and AR. And the question is, are all LEAs, so that would be districts, county offices, required to offer independent study? Are there any exceptions? So Mariella, do you want me to intro and then you catch on, or you want to answer?
Yeah, I already put the response in the question and answer, but I'm happy to reiterate that. My understanding is that LEAs may choose, but are not required to offer an independent study option. That requirement was for the 21-22 school year only because of COVID, and the requirement expired. I believe it was on June 30th of 2022. That's my understanding. Do you want to add
Yes,
anything?
Marilyn, I was thinking the same. Yes, the only thing I was thinking is that I agree with you. But since we now have the requirement for the instructional continuity plan, I would say that if that's your district's form of the instructional continuity plan is independent study, then there's kind of a requirement that way. Do you see what I'm saying? Yeah,
I agree.
yeah. So, okay, good. All right, next question. May a district set a minimum number of days for short-term independent study?
I think Josh wanted to answer this question. Is that correct, Josh?
No, go ahead, Marielle.
Oh, okay. I thought it said that on our little cue there. Okay, so again, what I believe is that even though California does not mandate a specific minimum number of days for short-term independent study, school districts can still choose to set their own minimum number of days within their policies. That is my understanding.
Okay, thanks. And I actually am not well enough informed about this. If a district is thinking of doing this and wants a more complete answer, please email us or call so that we can provide a more complete answer if you would like that. Yeah,
And legal counsel as well, I think would be a good one in this particular case.
yeah.
Yeah.
Okay, and then our last question in this area, again for independent study, is 15 days for short-term independent study a combined amount for the year? Or put differently, is there a limit on the number of times the student can be in short-term independent study?
I don't know if you wanted to answer this one, Barbara.
Yeah, again, I don't have, honestly, I don't have a huge amount of knowledge about this question. So I would, my response would be to please email us and I would look further into it. Marielle, I don't know if you have a more complete answer at this time.
I would say that this would be something also that you would want to consult legal counsel to make sure that it's being done properly. So I agree with Barbara that further looking into this is necessary.
All right. Well, thank you so much. So that's it as of now for this section, but please, if you, while we're presenting, if you feel like any more questions come up on these or maybe do our responses to these, please feel free to keep putting your questions into the Q&A feature. And we are going to have, further Q&A at the very end of our webinar. All right. So next slide, please. Okay, we're going to go on to our next section, which is called Health and Safety. And it's going to be led by Dustin. And Marielle is going to be kind of on the sidelines in case any legal questions come up. Okay, so Dustin, please go ahead.
Thank you, Barbara. Just a couple policies related to health and safety that we wanted to go over. I'm going to focus first on visitors and outsiders, and then go over some of the revisions to sex offender notification. Next slide, please. BP and AR 1250 were updated to remove the distinction between visitors and outsiders. This now requires everyone but staff and students to register upon their arrival. Additionally, the BP was updated to clarify that visits during school hours are required to be arranged with the principal or designee, and we changed from permissive to required the provision of a visible means of identification for anyone who is not a student or a staff member. Also, for any visitor who is in a school building or on school grounds to behave in an orderly manner. And then finally, if the principal requests that an individual who's causing a disruption to immediately leave the school grounds, that should be complied with. The big thing to keep in mind with this policy is that it plays an important role in school safety and ensuring students and staff are safe from potential unwanted visitors. It can be important to remind school site leaders to review the policy and ensure staff are aware of how to implement the procedures. Next slide, please. BP and AR 3515.5 was also updated, similarly reviewing visitors' visitation policies. This policy was updated to clarify that a district employee to whom offender information is disclosed, that person may only disclose that information when authorized by a law enforcement entity and in the manner authorized. Additionally, the policy was updated to include the purposes for which a sex offender's electronic mail address or internet identifier information may be used by the district police or security department. Finally, the regulation was updated to emphasize that components of the plan for receiving and communicating information about registered offenders residing within district boundaries are related to the safety of children. Additionally, the regulation was updated to include specific means for providing notice when the principal is granted permission to a person who is required to register as a sex offender to come into the school building. This policy and regulation require considerable collaboration with the local police department and having plans ensuring coordination. So when reviewing the updates, it may be worthwhile to talk with the designated point of contact for the district and the local police to ensure that information is being shared and flowing freely. Next slide, please. Any quick questions about visitors and outsiders or sex offender notification, Barbara?
Let me take a look.
Okay.
Let's see. So no questions. So we can just move right on to our next slide, please.
Thank you. Okay, now we had a few revisions to our operations policies related to budget, sale or lease of district real property, and claims and actions against the district. But first, I wanted to touch on some of the revisions in transportation. This policy was updated to incorporate expanded learning opportunities in the philosophical statement and reflect the new law, which requires the district to obtain specified attestations from any private entity with which the district contracts. And this also provides requirements for vehicles used to provide student transportation and adds qualification requirements for drivers who provide transportation for students. SB 88 is based on the recognition that more and more districts are contracting out transportation, and it's aimed to ensure that the vehicles and drivers meet safety standards. So it can be worthwhile to share these revisions with your transportation department or administrator, making sure they're aware. Next slide, please. BP and AR 3100 were updated to clarify that regardless of the option chosen for budget advisory committees, representation of the governing board members on the committee may not comprise a majority of the board. Since this having a quorum participate in any committee would in essence create a board meeting when they meet. Also, the BP was updated to reflect SB 114, which requires districts and COEs that receive the LCFF equity multiplier to include specific goals. And also the AR was updated to reflect AB 721, which beginning in 2027 requires hearing notification, date, and location information to be posted on the website. Next slide, please. BP and AR 3280. The BP was updated to delete the provision that until 2024, the governing board may elect not to appoint a district advisory committee for the sale or lease of surplus property that is not previously operated. Also, the BP added that before taking any action to dispose of surplus real property, the board is required to declare at a public meeting that land is either surplus land or exempt surplus land. Finally, the BP was updated to reflect SB 229, which provides the board may not pursue final action to ratify or approve proposed disposal of surplus land unless the board holds an open and public meeting to review and consider the substance of such a notice. Next slide, please. BP and AR 3320 claims and actions against the district. The first thing we did here was we deleted the AR, and that material was incorporated into the board policy. Additionally, the board policy was updated to reflect AB 452, which provides that there are no time limits for the commencement of actions for recovery of damage for claims of childhood sexual assault that occurred after January of 2024. Also, we referenced SB 558, which provides the statute of limitations for acts of childhood sexual assault that occurred on or before December 31, 2023. And next, finally, we generalized and made timeless language regarding the monetary limit for civil cases. Next slide, please.
Okay, well, thank you, Dustin. So we're getting to the point of the section about questions. We do have one question, which is, so in terms of transportation, it's about 3450. And the question is, does this apply to special education transportation? Dustin, I can start. I don't know if you want to answer it.
Go ahead.
I just wanted to let you know, generally no, and that we do have a specific policy on transportation for students with disabilities. So I'll give you the number in case that's part of what you're inquiring about. The number is 3541.2. So that should help. If you have further questions about that, please let us know.
Thank you,
Dustin, I don't know if
Barbara.
you wanted to add anything more to that.
No. Thank you.
Okay, so it looks like that's it. So let's move on to our next slide, please. And thank you, Justin. And that brings us to our last section on board governance, and Josh will be our presenter.
Thank you, Barbara. So we're going to talk about two policies, 9240 about board training and 9270 about conflicts of interest. We'll spend more time on conflict of interest. This has always been required, but we updated the policy to make it explicit that this is a mandate, that they need to have a conflict of interest code. As we found out, there are some local jurisdictions in which the city charter or county charter perhaps actually governs the ethics behavior of local elected officials. And so that may trump what the education code requires, the government code requires. And so we added a note for that. While it was always true that employees could seek legal advice if they had any questions about the conflict of interest code, we made it explicit. And there was a law change that requires school board members to receive training by January 1 of 26 on ethics, and every 2 years thereafter, assuming that you're a board member now and you're not running for re-election, right? So if you just got re-elected, it applies to you. And if your term ends in less than 2 years and you seek re-election, it applies to you as well. We do offer at CSBA ethics trainings in case folks are interested. And then it made some changes that we'll get to the next slide about accepting, soliciting, or directing campaign contributions. So this comes from two statutes, SB 1181 and 1243, and they're not I had to read them like 4 or 5 times to really sort of understand it. But trying to break it down sort of just fundamentally, this applies to contributions of over $500. When I was a school board member, there was actually a campaign contribution limit of $250 per individual, and so this wouldn't necessarily have applied. But most districts, it's not going to be that. But you have to be very careful because this is about a proceeding that involves a contract, license, permit, or entitlement for use. So what might that be in the district context? Because this law applies not just to school districts, but it does incorporate school districts. So a lot of stuff with facilities. So be careful with facilities. Charter school, perhaps, maybe facility use agreements, things of that nature. Not so much permits or licenses, but depending upon the contract, it might apply. But basically, there are prohibitions against receiving contributions in the prior 12 months. If some interested party in a contract gives you a contribution, you can get around it by disclosing and recusing, or disclosing and then returning the contribution. If the proceeding around the contract, license, permit, or entitlement for use is ongoing or has happened in the prior 12 months, there is a more strict prohibition. This one does apply to superintendents. Obviously, you may not, as a superintendent, be accepting contributions because you're not an elected official, but you may be soliciting contributions on behalf of, say, a bond measure or parcel tax. So you have to be careful there. You can cure it by returning, the money above 500. And some of this stuff doesn't apply to all contracts. So competitively bid contracts, labor contracts, personal employment contracts, small contracts, contracts, with another government agency. So it's complicated. It's not clear. Always check with counsel. Or as sort of a general practice, don't accept contributions of more than $500, and then this doesn't apply to you. So, there's various ways around it. But this, this could have some, real impact. And it isn't always clear if someone has an interest in that contract, right, or in that license or entitlement for you. So, make sure you're careful. Okay. We updated this other bylaw 9240. Sort of the explanations are there. Added some budget pieces. Added the same ethics training requirement if you added in 9270. Things of that nature. I just want to note that board members can attend the same training. So a majority of the board can attend the same training, but don't discuss amongst yourselves anything that is like before the board's jurisdiction that isn't sort of part of the scheduled program, right? So if they're, if you as a district are looking into, say, employee housing, and you attend a training about employee housing, that's fine. You can discuss employee housing, but let's say you're talking about something else, right? And you want to talk, I don't know, about like your negotiations. You can't do that, right? So you really have to stick to what's on the agenda and not make it more specific to your context or discuss a different topic. And I will stop there.
Okay, thank you so much, Josh. And now we're getting to next slide, please.
No questions, Barbara? We're just gonna move on.
Well, no, we do have questions, but we have our general questions for the the end questions. We don't seem to have any questions specific. Oh, no, they've been added. We do have some. I'm sorry, let's go back. Okay, so first question, what happens if board members do not complete ethics training?
I don't know, Mario, if you want to jump in on this one, but the law is not clear on this one. So I think it will probably be worked out if if it doesn't happen, but don't be that board member. Please don't be that board member where it's our test case. Marielle, you want to add anything?
All right, thanks.
No, I agree that reports may be the only available recourse at this point, but as these individuals come forward who haven't fulfilled the requirement, I'm sure we'll learn how and
and if a lot of board members don't do it, then someone's going to pass a law imposing a harsh consequence. So for all our sakes, please just do the ethics training.
All right, thank you. Next question. Is there a duty to vote for board members unless there is a genuine conflict of interest? I guess the concern with this question is that some board members are not wanting to vote if it's a controversial issue. So my guess is they're trying to abstain. Yeah.
Yeah. So no legal duty to vote. You can abstain. If you are required to recuse, an abstention does not suffice. You have to actually leave the dais, and in most instances leave the room. So you can't be accused of influencing the vote, even if you don't vote. But you do have to, sort of a political obligation to your constituents. They elected you to act, to govern. But if you decide to abstain as a board member, there is no legal consequence for that.
Okay, thank you. Two more questions in this section. Are board members considered staff? I think this is one that you might be able to help with. So the question says, can they seek legal counsel through CSBA at the expense of the district without prior approval of the superintendent?
So the short version, oh, go ahead, Marielle.
No, so CSBA Legal Services represents the district and the board as a whole, not individual board members. So generally, we require that the inquiries come through either the board president or the superintendent.
Thank you. Josh, did you want to add to that?
Great.
Okay. So we keep having questions come in, let's see if we can do and then move on. If some keep coming in, we will push those to be at the end of our presentation. So what kind of documentation is maintained for the ethics training?
So the law doesn't specify, but you get a certificate, you just want to make sure that there's some proof that you signed up and attended. Mary, I don't know if you want to add much on that, but each provider will do it differently, but just make sure that you keep it documenting that you've done it.
I agree. CSBA gives you a certificate. I'm assuming that most other providers do the same.
Okay, perfect. So our last question in this section on conflict of interest and asking, does this apply to a board member receiving a large campaign from a special interest group, such as the example is such as a charter school PAC?
It depends. So if there is someone like leading the pack that has a financial interest in the proceeding, then it would apply. So it doesn't necessarily need to be the same legal entity. If a charter school or if let's use a different example. So if a developer has a PAC and contributes more than $500 to a school board member, say, I don't know, right before the election, and then one of the first things taken up by the board is a contract that is not competitively bid. That's one of the exceptions, right? That relates to the financial interest of that same individual. Then potentially there would be a problem there. So you have to sort of think about the exceptions, think about the financial interest. It doesn't prohibit contributions generally of over 500. It just says that if you receive a contribution, then you can't basically participate or vote on the or participate in the decision on the proceeding itself. So if you have questions, you should definitely about a specific situation talk to counsel for sure, because conflicts of interest stuff are complicated, and you want to get specific responses on each situation.
You do have one more question on this, but I think we'll take that at the end with the other questions, just so we can keep moving along a little bit. So next slide, please. So we just want to now, please stay on, because we're going to answer the questions that are remaining on our list here. But we're hoping before we get to that, if you could please participate in one more poll, which was how you would rate this webinar. Again, it helps us to try to provide as good of a service as we can to you. So please be honest. 5 is incredible. 4 would be really helpful. 3 good enough. 2 barely okay. 1 not worth my time. So I believe we're going to see the poll in a minute. I think Josh will bring up the poll. There we go. So if you could just take a few seconds to complete it. All right, and then we can look at the responses, although this is really for our purposes. So we'll just look real quick. Well, good. It looks like at least like most people found it either incredible, really helpful, or good enough. So that's great. And thank you for letting us know. We'll aim to get more into the incredibles, but really appreciate your participation. Okay, let's look at the next slide, please. Okay, so I think we're to our final Q&As. So let's try to move through these quickly so we can get to all of them rather than leaving some undone. So the first 2, 3 actually have to do, well, there's a bunch actually for independent studies. So let's try to take those together. One question is synchronous learning required for independent study? And Josh, I think you can take down the results of the poll. So for the first question, I don't know, Mariella, if you want to take that one. Is synchronous learning required for independent study?
Sure. So it depends. My understanding is that it depends on grade levels. So for TK to 3rd grade, I believe that students do have to receive daily synchronous or live instruction. And then from grades 4 to 8, There must be an opportunity for daily interaction and weekly live instruction. Opportunity is not defined. And then for high school students, there must be some form of synchronous instruction. So some wiggle room there, except for the transitional kindergarten to third grade, which seems to be the most specific there.
Okay, thanks. So for our next independent study question is for the instructional continuity plan, is there guidance of how to implement the independent study agreement? If it needs to be in place before independent study begins, but an emergency closure happens, is it best to have them basically in place before the start of the year? And I mean, my general is I hadn't really thought about that, but that's actually a good point, and it would be great to have it for each student. I think it's really something to address maybe with your legal counsel, because there are also some very specific requirements of the independent study agreements. And I don't know if all of those can be done in advance. It would need to be carefully looked at. But I do see the district's concern of the County Office of Education and the desire to have one in place for each student before an emergency were to occur. Marielle, I don't know if you have anything to add to that.
Yeah, I agree with that, and I would emphasize the need to consult legal counsel.
Okay, thanks. Okay, so a couple more, or at least one more with independent study. I'll keep looking to keep them together. Okay, so the question starts with, I understand that short-term independent study is 15 days or less. What should a board do to make sure policies in place in the event a student has a medical emergency that requires long-term independent study? I have a feeling that would be something that would be done on an individual basis. And if a particular student needs long-term independent study at that time, it would be transitioned to a long-term independent study agreement. But Mariella, I don't know if you want to confirm or differ with that.
I agree with you, and I hate to keep saying this, but because it is an area of the law that has received a lot of changes recently, this is something else that I think a district or county office would be well served by consulting legal counsel.
Thank you. Okay, so these next two questions are just making sure we're covering all of them. Are not about independent study. One is about conflict of interest. It says, what is the policy around board members gifting all teachers at the school, especially close to an election? Dollar limits or conflict of interest with a question mark. So I guess if we could talk a little bit about the thought of if that's a good idea to do or not to do.
Yeah, so the board bylaw that we covered doesn't directly touch on this question. And there's a few considerations. So, one is are these gifts using district funds? And if so, is it an appropriate use, right? Are you helping teachers with their class materials, or are you buying them coffee? I don't know, what it is. Depending upon what it is, it may be subject to collective bargaining, right? So you have to sort of flag some issues there. If you're using, personal dollars, not necessarily problematic, but there is the common law around conflict of interest does apply to the perception of a conflict of interest. So if it could be perceived as buying votes, for example, or influencing their votes, that might be problematic. But without sort of knowing more, or is there a history of this, right? Is it related to holidays, or what have you? It may not be problematic. So it's and the common law around conflict of interest is not as bright line as statutory conflict of interest, and so it's much harder to figure out when it really applies and when it doesn't. So that might be a good situation, to request, that you get a confidential memo from, district council that is shared with board members about that kind of practice.
Thanks, Josh. That's very helpful. I believe our last question for today, but again, please, if you have further questions, feel free to email us, is do we have a time estimate of when an updated BPAR 5145.13 response to immigration enforcement might be released? So Josh, you want to handle that?
Sure. We did a webinar on this topic last week, not the policy specifically, but generally about response to immigration changes and enforcement. So we're working on it. We're trying to get it out soon. We don't have a specific date to share publicly yet. The Attorney General says that districts, quote, should update their policies by May 1, consistent with the latest guidance that the AG put out in December. There are a number of state laws that are, perhaps going to be coming that could affect that policy as well. And as we've seen, there are things are changing almost daily at the federal level around this kind of stuff. If you have specific questions, please feel free to reach out. And we are working as best we can to get something to you, knowing also that there are other changes on the horizon. So we're trying to balance that so you're not completely changing things week to week.
Yeah, thank you, Josh. Yes, a lot of moving parts. Okay, so that will conclude our question and answer. And so next slide. Just thank you and farewell. And please, again, feel free if there was any more information you want about the webinar. Remember, you will receive, everyone will get the slide deck as well as the webinar itself. Just email us if there's anything else. And just thank you so much for joining us. And I hope you feel like it added to your knowledge of our policies. All right, thanks so much. Have a great rest of your day.